Law&Crime Network. My name is Bob Bianchi, and I'll be taking it from 12:30 to 4 o'clock today. Okay, going back to McStay family murder. So let's remember here that mom and dad and the kids are gone. Cops think that they may have skipped out to Mexico. Years go by, and a motorcyclist in the desert finds skeletal remains, and ultimately it is concluded that those are the skeletal remains of the family. There you see the two young children right there. Such a shame. Let's go in the Mojave Desert with our very own Kathy Russin to get a little bit of a feel and a little flavor for what the crime scene actually looked like, because it's very relevant in terms of how the prosecution has moved forward in trying to get Charles Merritt convicted of that crime.
We are currently at the site where the remains of that family of four was found at the end of 2013, nearly 3.5 years after the family went missing. A motorcyclist came across the skull here, and investigators eventually found two shallow graves with the remains of the family. Now, this location is just north of Victorville, California, in San Bernardino County. Prosecutors say Charles Merritt killed the McStay family in their home in San Diego County and eventually drove the bodies here and buried them. It was a 3-pound sledgehammer. The cause of death is said to be blunt force trauma to the heads of this family of four. The prosecutors in their opening statements say that Charles Merritt drove them here and that you can see a set of tire tracks. Now, it's very hard to see them now because so much time has gone by. I can actually see a little bit of them, but they were very clear, but even back 3.5 years after the family went missing. There's another set of tire tracks about 20 feet over. There are two actual grave sites. This is a memorial that the family put up, but just to the bottom of this is where the first grave was. The second one was about 20 to 25 feet over there. Now, the defense in their opening statements say that more evidence points to a third business partner, Dan Kavanaugh. They also say that evidence here at this scene show that there were more than one person that committed this. They told jurors they will see the two sets of tire tracks and they will see that they're not consistent with the same vehicle. They also put the theory up that Joseph McStay was killed, brought here, and that Summer and the boys were brought here alive and then killed here. They say that the family was not killed at their home. There is no evidence of any blood or any DNA found at the home to show the family was killed there. The trial is expected to last up to 6 months, and Charles Merritt will face the possibility of the death sentence if he's convicted. I'm Kathy Russin for Law&Crime.
Wow, that's awesome. I got my hashtag 4041. Gene Rossi was on the show before with Jesse. Gene, welcome back. It's good to be with you. It's been a little while since we've been on together. Kathy Russin out there from the Law&Crime Network, right there, right at the gravity epicenter of where these bodies are, where they came to rest. I always used to feel this way as a homicide prosecutor, like how, kind of like thinking through, like how somebody's life ended up like this, because obviously it's very traumatic, but nothing more powerful than that demonstrable evidence. Do you think they're going to be able to get out to that crime scene, Gene? And do you think it's important for the prosecution to be able to try to at least argue for that if the court doesn't grant it, at least argue for it?
You know what, Bob? I was just thinking of this. If I'm the defense team, I want them to go to that grave site. Here's why. They're trying to lay the blame all on Mr. Merritt. The crime scene suggests the following. There is no way that Mr. Merritt could do that by himself. There are two vehicles at least. There are two grave sites, 20 yards, many feet apart. It suggests to me that either Mr. Merritt had other people helping him, or if it wasn't him alone, then it was some other cause. Was it the individuals who came from Mexico? Was it Mr. Kavanaugh, who may have gotten other people? I would want to go to that gravesite because it actually supports the defense's case. There are two sides to every story.
Yeah, you know, I don't think that going to the gravesite, Gene, is the wow factor, like, oh, he's the one who did it. I just think that it has a visceral impact on the jury, and you want to be able to do that as much as possible. Of course, the cell phone data is going to be very, very relevant here with regard to whether or not Merritt's cell phone was pinging off cell phone towers nearby where the gravesite was. Because other than that, they've got a very kind of weak case because they keep pointing to this guy, Dan Kavanaugh.
Yeah. Now, I will say this. If I'm doing a closing argument for the prosecution, that ping of his cell phone, Mr. Merritt's cell phone near the burial site, that is extremely bad. Plus the DNA on a drive, the radio, the steering wheel, and in the car, those are two pieces of evidence, plus the QuickBooks. Don't get me wrong, there's evidence that point towards Merritt, but I got to tell you, this is a case, and this is why I'm fascinated. It has arguments on both sides. It really does.
Yeah, that's why we try to, we pick these trials not only because of their national significance and their importance and gravity. And I understand that sometimes people get a little miffed at us as lawyers, Gene, when we say it's a great case. And what we mean by that is that it's got so many permutations to it. It bubbles up to the forefront, the lawyering and the nuances of real trial law. You can't get it anywhere better, Gene Rossi, than gavel-to-gavel coverage at the Law and Crime Network. Stick with us. We hear that McStay is about to spark up soon in the courtroom. We're going to go to a break. We'll be right back. Okay, well, welcome back. So in the McStay case, we have this witness now, Susan Heckman, who is McStay's business associate. Gene Rossi, why is the prosecutor putting this witness on? And talk to me a little bit about the same objections that are being made repeatedly by both sides, volleying back and forth about foundation and being overruled repeatedly by the judge. What are your thoughts?
I'm going to do the objections first. My view when I was a prosecutor, now defense attorney, is you object very rarely unless it's very important. And to me, foundation, when you have a Miss Heckman on the stand, she knows the book, she knows the invoices. I would never object on foundation. What is foundation? Foundation is when you got a document in front of somebody like a Miss Heckman, you have to show that she knows what she's talking about. She knows the policies of the business, how invoices are generated, when they're generated, why. You got to have some cement for the foundation for the house, which is the document. So that's what a foundation objection is. You can't just speculate. So that's the foundation thing. Why did the prosecution put her on the stand? It supports their theory that from February 4th, when they left, when they went missing, right, and even months after, Mr. Merritt was suffering financial straits. Mm-hmm. And it could be the result of a gambling habit, overspending, profligate spending, and that motive continued for several months, if not a year or two, after the murder. That's it. Right.
Goes right to their motive, Gene Rossi. I agree with you on all points as typical. Guys, we're going to have to take a real quick break, but we'll be back with more of this fascinating trial. Gene, I honestly, I've never seen anything like this. I don't want to be like overwhelmed here, but this foundation, I went to the chat room, Gene. I went to our jury, the Law and Crime jury. They're getting tired of the objections. Forget about the style points that as a prosecutor, you want your witness to be able to answer without you looking like you're freaked out about what it is they're talking about. But this whole thing about foundation and speculation and hearsay, this is her statement. It's not just that it's relevant or whether she has personal knowledge. It can go to an inconsistency. How is this even being argued that she can't be cross-examined? And, Gene, why are they not making a record at sidebar as a defense lawyer to say, Judge, you are limiting my ability to properly cross-examine this witness?
I have to take some medication because my blood pressure is really high right now.
Holy cow.
I want to tell your listeners this. Do not pay attention to any objection that was made and any objection that was sustained or overruled. The rules of evidence during this witness were thrown out of the courtroom.
Yeah.
I couldn't understand half the objections and half the rulings by the judge. My mind was exploding. And here's the other thing I got to say, and I'm a former prosecutor, you are too. That witness was not prepped properly. That was a very important witness for the government, and it wasn't prepped properly. When you have to constantly refresh the memory of a witness based on statements they made, that means you haven't done sufficient preparation. And the objection regarding hearsay when he's trying to impeach her with an inconsistent statement, where did that come from?
He put the defense lawyer, in fact, as a defense lawyer myself, Gene, I would have been like, Judge, I need a sidebar right now. No more speaking objections in front of this jury, which I don't think is appropriate in the first place. But moreover, to your point, Gene, an exception to the hearsay rule is inconsistent statements. The credibility of a witness is always relevant. Always relevant, so long as it's not excluded under Evidence Rule 403 or too far attenuated, if you will. He's asking her about a contrary statement she gave to the detectives when haphazardly he got to the point her memory was better then than it is now. I just can't believe he would just walk away by the judge saying sustained. No, I need to go to sidebar, make a record, Judge.
But also, Bob, what was left in the jury's mind before this witness was let go is that she told the detectives in 2010 or in 2011 that payment went to Dan Kavanaugh. And the prosecutor objected, overruled. Dan Kavanaugh, I told the detectives, Dan Kavanaugh got the money. That is money for the defense, because they're trying to place it on the bloody hands of Dan Kavanaugh.
Gene, you know what? Great point. And you know what's really a good point too, Gene, is that you had to remind me of that. Because when that great answer came out for the defense, which points right to their defense, it should have been hopped on by 4 or 5 follow-up questions, because, in my mind, because it was really good, rather than getting washed out with all of these specious, in my mind, unrecognizable objections. In any event, we're going to go to a break. We're going to be right back. Okay, so Jeffrey Martin is the boss of Susan Heckman, who had just testified before Gene Rossi. They're talking about a 2010 fountain project around the time, days before the disappearance. Basically, what we're learning there is that he was on the project. He wasn't getting the fountains, that the defendant, Merritt, was his point of contact, that Merritt was requesting additional money. He wasn't receiving the fountains. Eventually, he got the fountains that were, I guess, in disrepair because they weren't assembled, took all the stuff, all the pieces, brought it with him to Ohio, and then hired additional subcontractors in Ohio to assemble those fountains. So we know that financial motive is the prosecution's motive in the case. What is this testimony leading us towards? Is it just to build the foundation blocks here, or is there a wow factor, Gene?
There's no wow factor. This is just no pun intended, another brick in the wall. And I have to compliment the prosecutor, because you and I were kind of hard on her. But this witness was very well prepped. She got out her points and she ended it. And unlike the Heckman direct exam. So I got to give her an A-, A+ on this witness. But it's just a brick in the wall. There's no wow.
Yeah, and just so the audience understands that, a lot of times in a case, a good prosecutor is going to put those bricks, if you will, in the middle of the case. They don't have a wow factor. Primacy and recency is always important in every little segment of the trial that you do. So the financial motive in this case exists, but is it eliminating the defense's attempts or argument that Dan Kavanaugh also had financial incentive in this case, which the judge blocked some of that evidence from coming out. But to me, I'd be renewing my application as a defense lawyer, saying in light of this evidence coming out from the prosecution, I should now be able to bring out the Kavanaugh information that you previously excluded, Judge. What do you thought?
Yeah. What my thought is this. If I were the defense team, at every opportunity, Bob, I would ask for a sidebar. I'd make a record, and I predict this, and I know it's going to happen. That judge probably now realizes he made a bad ruling in not letting them put on the Kavanaugh defense. And what's going to happen is that the prosecution is going to, the famous open the door. And there's going to be a moment in the next 4 months, 5 months, where the prosecution's going to open that door ever so slightly so that the defense can put on their Kavanaugh case, because if they are not allowed to put on their Kavanaugh case, I predict if there's a conviction, it will be reversed.
Gene, we talked about this before all of this, that whenever a judge is excluding third-party guilt or the defense to make an argument that somebody else is the person that did it and they just rushed to judgment with regard to one but didn't consider the other, you're opening the door to potential appeal. God knows on the Law&Crime Network we have to keep covering trials that have to be retried because of evidential problems that occurred, prosecutorial overreach. And now what Gene Rossi is saying, Gene, very interesting tactical question for the defense. Do you just leave it and try not to go through that opening of the door for an appellate issue, or do you go to the court and say, Judge, you need to reconsider? I'm more of a reconsideration guy, Gene. We'll get your answer on the other end of this break. Stay tuned for more of this fascinating case. Okay, so we have the judge asking some questions. Gene Rossi, same question as we did with Susan Heckman. This is her boss talking about these fountains and all things fountains. Moving the ball forward, is this another brick, as you were calling it? And if so, how is this differing so much from Susan Hendricks' testimony?
Susan Heckman?
Heckman, I apologize.
Well, I got to say the direct exam, the initial direct exam of the prosecutor was an A+. The cross was good. And here's what happened. They took a good witness and just diluted it with the redirect and the recross. There was so much confusion at the end, the judge had to step in. That's not very good. So this is definitely not a wow witness. It's maybe a meow witness, okay? I got to tell you, things are getting very, very muddled.
Yeah, in fact, it's funny. I went into the chat room and I asked, we get the basics. We understand what happened here with these fountains. We understood that with the last witness. And I asked, can anyone give me an idea based on what you're watching, because these guys are avid and they're our jury, what you make of this? And people are saying things like, I don't know, I can't get it, I'll have to look again tonight. Well, if our Law&Crime people that are in that chat room who watch this stuff and love this stuff day in and day out, you wonder the confusion in the jury's mind. And Gene, is what you're saying that you believe the defense actually scored points in that the judge ultimately had to clarify things? That is, it's the prosecution's witness, and if the judge has to clarify, it means something got lost?
Absolutely. And when I do my close, now I won't, but if I was doing a closing in this case and I got to Heckman and Jeffrey Martin, I would bring out members of the jury. Why did they bring those two witnesses in? All they did was confuse the matters. As a matter of fact, you may recall it was so confusing, the judge had to ask clarifying questions.
Right.
That's what I would do. Yeah,
and certainly as a prosecutor, with any witness, even as a defense lawyer, you want your witness to paint the picture really crystal clear so that it's not confusing, so the judge does not have to interrupt and try to clarify things. Gene Rossi, always an awesome opinion. Appreciate it. Fascinating case. Gavel to gavel coverage. We got to go to a break. Don't go anywhere. We'll be right back. Okay, welcome back. So they are taking a mid-morning break in McStay. So we have an opportunity to go to some great testimony that came out last week. Last week was all about finding the body and excavating that body. And we had one of those forensic anthropologists that was on the witness stand and provided some, I always love the anthropologists. They always provide very interesting data. And of course, it's very crucial for a trial. And that is Dr. Alexis Gray. She's a forensic anthropologist. She testified last week. Let's take a quick listen while we have an opportunity during this break.
Remains which then took up forward, and then I had seen some remains sticking out that I thought probably indicated a fault. Okay.
You indicated that you saw some remains sticking out. Do you recall whether they were sticking out at grave A or grave B?
Well, you would have to tell me which one we designated as grade A or grade B. I don't remember.
So if the one in front of you, if we looked at that and said that's grade B.
Okay, grade B. Then it would be grade A.
Now, when you do this quick canvass, how worried are you about contaminating anything around you in terms of potential evidence?
Moderately. I mean, you have to weigh our need to get over a large distance versus preserving absolutely everything. In the desert, that's not possible anymore. So many factors have come in, from animals to weather to other people, coming through and all of that. The idea that you would have a pristine scene is something that you have to discard very early on.
Well, as you're walking around that day, can you tell us, you indicated that you saw tire tracks leading up to this particular grave that we see in the picture. Did you see other things indicative of animal activity?
Yes.
Did you see other tracks or things of indicative of maybe people riding dirt bikes or driving through there?
Yes.
Did you see other things indicative of footprints or anything like that?
I don't think I saw anything in terms of footprints. There was general cultural debris. Anytime you're out in the desert, there are cans and shotgun shells and all of this unrelated material that you kind of keep an eye on in case it turns out to be related, but most of the time you kind of walk past it, skirt it.
So as you go to this scene and you ultimately do this quick canvass, you indicated you are not dealing with a pristine crime scene at this point.
That is correct. No, but I mean, when you say do studies, I hear do research. Okay. Have I done research in regards to DNA? No. Have I collected a great deal of DNA? Yes. Did I attend classes that were about DNA during my graduate career? Yes.
Is it practical to try to recover DNA from a crime scene like this?
Objection, Foundation.
No.
Your Honor, I haven't heard. Can we be heard?
No. The objection's overruled.
It isn't practical because the possibility for contamination just from the local environment is too high.
When you
Foundation.
Overruled.
When you say the local environment, what is it that you're referring to?
I'm talking about that desert with, the plants and the decomposing organisms and all of those things. DNA can be recovered in a lab from the remains or from anything if it's intact, but it's not something that we would be trying to necessarily recover at that location.
Gene, our producers do an amazing job because that is exactly the clip that I was hoping they were going to pull out from this testimony that I want to talk to you about. We didn't have a chance last week, and I know you, my man. I know that this is going to be amazing on multiple levels. The first thing is the prosecution gets done. I've never seen this before in my career, proving she's not an expert in something, and then asking her to offer an expert opinion, which I'm pretty confident is the basis of the objection of the defense lawyer, which was shut down. And as we've indicated before, he wanted to make a record, which is the right thing to do, and was denied the ability to do that. So you tell me, Gene Rossi, 30 years at the DOJ, over 100 trials. How does somebody say that they're not an expert? They only went on a couple of classes with regard to DNA, but then say that the potential of getting DNA, because it wasn't a quote-unquote pristine crime scene, was not possible, which, I may add, is ludicrous.
Well, let me tell you something. They just teed up a reversible error argument for the defense is that if there's a conviction. When you proffer, when I was in EDVA federal court, when I laid the foundation, brought out the qualifications, the CV experience of an expert, I would turn to the judge and I say, Your Honor, Mr. Robert Bianchi is an expert in the following areas. We have noticed it. It's docket number blah. And there would be a circle of expertise that they could talk about. What happened here is she went outside her circle of expertise, and that is why they made that objection. That's an appealable issue. Number two, what the defense should do is file an offer of proof as to why they're objecting so that the appellate court will really know the basis for the objection.
Yes, and Gene, this is the problem that I have when an attorney has to go to sidebar to make a record and being denied that is you are correct. You need to cover the record so that the appellate division clearly understands why you want to do this. Gene, last point is a common sense point because to me that plays better to a jury than anything else. How can you say that it's not a pristine crime scene and therefore you couldn't get DNA, yet you got DNA, you submitted that DNA, and you're only saying that now, would be my argument as a defense lawyer, when it didn't come back to any of the victims or, moreover, my client? Why would you do it if it can't be done?
Well, I can't explain why. I can't explain that. All I can say is common sense suggests, even if you're not an expert, Bob, that in the Mojave Desert, after I don't know how many years, 3 years, that it's going to be very difficult to obtain evidence. And sometimes you don't even need an expert to say that.
Yeah, Gene, I didn't want to put you on the spot, but that was more of a rhetorical question I would ask to the jury, because the fact of the matter is they did recover human DNA from relevant items of evidence in the case. It just didn't match. So to say you can't do it now, to me, is disingenuous. We got to go to break. We'll be right back. Thanks, Gene. Welcome back to the Law and Crime Network. We are doing the McStay family murder case. Hey, guys, listen, we have a break right now, so this gives us a really good opportunity. Our producer's cutting out things that are really important in the case and crystallizing it only like the Law and Crime Network can do. Let's go back to the defense opening right now so that we can get a flavor as to where the defense is going to see whether or not, through their cross-examination thus far, they're building the blocks to show some reasonable doubt, at least to one juror, in order to at least get a hung jury, potentially an acquittal. Let's take a look.
McStay family, we see, victims. We do. And we want justice for them as well. What you got to realize is Charles Merritt, which everybody calls Chase, that was his best friend. Joseph was his. Joseph's brother will say, yeah, Chase was Joseph's best friend. The loss is also to him. And we're focusing on that. It's funny, during the people's opening, they say, he wasn't there when the police were called. And then they kind of passed over the fact he's the one that contacted Joseph's mother, Susan. Says, Susan, it's now Tuesday. I haven't talked to Joseph. We talk every day. Sometimes we don't talk over the weekend, but we haven't talked in a couple days. There's a problem. We need to call the police. No, I'm sure they're just gone. Well, I'm going to go to his house and check on him. Okay. So he does. Then he's in contact with the family. We need to call the police. Joseph's brother, Michael. No, I'm sure he's just on a surfing trip or something. Don't worry about it. No. Serious, guys. We need to call somebody. The dismissive of he didn't care, he didn't want to call the police, he's the one that pushed. Michael finally said, we'll go take a look on Saturday when I'm not working. And that's when Michael met with Chase down at the house. Let's call the police, let's call the police. We'll just wait till Monday, okay? Let's just wait till Monday. The only urgency to find Joseph was Chase.
Welcome back. That was the defense opening statement there. Now we have one more clip we're going to show you, and on the other end of that, I got one of my best favorite guests in addition to Gene Rossi that's here. Going to remain anonymous right now. If you're in that chat room, I'd love to see you guess who it's going to be. But before we do that, guys, let's go to Chase's police interview, the defendant's interview here, because there's also something that I think from a common sense standpoint in this case may be the thing that pushes the prosecution to the goal of guilty in that interview. If you guys have been following this trial, you know what it is. Let's take a look.